Hello and welcome to Legal Basics with Syra Law Global, and my name is Sian. Today we're going to answer one of the questions that has been most recurrent in your feedback from season 1, and that is the remedies. My guest today is not new to the screen. She's been here before. We've discussed some other legal matters, but still I will let her introduce herself.
Thank you so much, Sian. My name is Lorraine Oyombe. I'm a legal practitioner in Kenya. I've been an advocate for the last 7 years.
Oh, karibu.
Thank you.
Lorraine, please explain what because we've had a broadcast on termination generally on how to go about it. Just please explain to us what is an unfair termination.
An unfair termination of employment is where the court finds that there was no valid reason or there was no fair procedure followed. So the valid reasons for terminations are normally reasons related to the capacity of the employee, related to their conduct or their performance. And the fair procedure is stipulated also in the Employment Act, where it provides that before you terminate an employment because of incapacity, illness, or conduct, then you have to give the person the reasons and an opportunity for them to explain themselves in the presence of an employee of their choice or a shop steward if they're in the union. So that's the fair procedure we're talking about.
Okay.
Yes, and also a reason for termination, a valid reason could be an operational reason, and that mostly relates to issues of retrenchment or redundancies. And also the procedure for that is provided in the Employment Act under Section 40, which requires you, of course, to give notices to the employee, to the Ministry of Labour, and to the union, and to pay a certain package, which is a severance pay. And that's in a nutshell.
All right. So in season 1, we dealt with how to go through a redundancy. So if a redundancy was not properly done, then the employee would have recourse for unfair termination.
Yes.
If the disciplinary process was also not correctly done, they would also be going to court for and claim that there's unfair termination.
Yes.
So now, and we've also dealt with the court process, but what we didn't deal with is with the content. What am I asking the court if I've been unfairly terminated?
Okay. So when you have gone through the process and you feel you've been unfairly terminated and you have your suit, you are asking the court to compensate you for that action that was unfair.
Yeah.
You are asking the court to pay you what you are entitled to if you had been treated fairly. And you are also asking the court to consider the fact that you may have also had other issues that were not paid in the course of employment. For example, if you are raising issues of underpayment, you want that to be corrected by you being given the difference. So there are so many aspects to that claim that you could have, and it's always important to be very specific about them to make sure you have listed them in your suit, and to make sure if it involves monetary amounts, for example, they have been saying underpayment or there were allowances you were not paid, state them explicitly so that all those items are tabled before the court.
Okay.
Yes.
So when a person now approaches the court, they have to ask for specific orders, right?
Yes.
So some of the orders, as you've said, is if they were being paid, underpaid, or this country has a minimum wage standard. So if you used to earn less than your minimum wage, that's something that the court can correct. What are the other things that classically claimants ask for?
Okay. So they also ask for reinstatement, which means basically being given back your job. Or being given a job which is similar. And claimants also ask for damages, which is a compensation beyond what the Ordinary Employment Act gives. So damages are meant to compensate you for an injury or a breach of your rights. And also they normally ask for, we've seen very unique scenarios where even within the employment relationship. There's been no termination, so people have got to court for injunction actually in
Yeah.
between.
Mm-hmm.
So you can go for an injunction. Maybe if you anticipate you're going to go through that unfair process,
Mhm.
it has been stopped
Yeah.
by courts.
Mhm.
So I would say the options an employee has are quite many.
They're quite many.
Yeah.
Okay. So now when an employee is asking for the money that they would have been paid had they been given due notice, in the
Yes.
event that during the termination process they were not given due process,
Mhm.
what are the attitudes of the courts towards that, and what do the courts consider?
So when the employee is asking for notice pay,
Mm-hmm.
the courts normally consider what was in the contracts of the parties.
Mhm.
So, for example, if you had a contractual notice period
Mm-hmm.
of 1 month, and this means that in the initial contract you had with your employer,
Mm-hmm.
before terminating your employment,
Mhm.
your employer was supposed to give you 1 month's notice,
Mhm.
then that is what the court will award you. The
Okay.
court will not award you 3
More.
months.
Okay.
Yes.
Mm-hmm.
And the court should not award you less, because you're already
Mm.
entitled to the 1 month that
Okay.
you agreed as parties to that contract.
And if it was 3 months, the same way?
The same way.
Okay.
Yeah.
Now, as far as damages go, is there a statutory floor and a statutory ceiling? Sorry for using legalese, but is there a minimum amount and a maximum amount that the courts can award you in terms of damages?
Yes.
Mhm.
For unfair termination, the
Mhm.
Employment Act stipulates that there is a maximum of 12 months' salary as
Mhm.
compensation,
Mhm.
but also courts have awarded beyond the 12 months
Mhm.
in unique cases where they find other aspects of the employment law were breached. For
Mhm.
example, discrimination.
Mhm.
You can get damages which are not pegged to your 12 months salary for that discrimination,
Mhm.
because that is not an item that is really part of the contract of the parties,
Mhm.
but the courts normally give damages outside the section 49.
Ah, okay.
Yes.
Okay.
So those are the things you can claim. So if you have a claim which involves discrimination, you're not limited to the 12 months compensation.
Mhm.
You can seek further damages on top of that.
All right.
Yeah.
So what is the rationale behind
Mhm.
the court giving you these damages?
Okay.
Mhm.
So as I've said, the court can give you up to 12 months salary as compensation.
Yeah.
With what
Gross or net?
Gross, which includes your house allowance.
Okay.
Yes.
Mhm.
So, but that is also quite debatable,
Mhm.
and I'm sure we can delve into it for days on end. But I'll just leave it as the simple fact that it includes your house allowance.
Okay.
So, what the courts have the range of doing is they can give you any amount of compensation from 1 month
Mhm.
to 12 months.
Can it be lower than a month?
It cannot be lower than, yes, it can. You can get no compensation actually.
Ah, okay.
And you can remind me, I'll tell you cases where that has happened.
Mhm.
So what the courts normally consider, first of all,
Mhm.
is the breach that the employer has made.
Mhm.
The courts consider also how your own conduct as an employee contributed to that breach.
Mhm.
The courts also consider the practicability of the kind of payments
Mhm.
they are asking you, the compensation will result in the sense that there are times when maybe you've sued a company which truly went down.
Yeah.
So even if you order 12 months compensation,
Where would they get it?
Where
Yeah.
would they get it?
Mhm.
And also the courts consider the manner in which the termination happened,
Mhm.
because I've seen judges writing and saying that the person was exited in a humiliating way,
Yeah.
and because of this reason, I'm giving 7 months, 8 months.
Mhm.
What is important is for that reason to come out. Why it's 7 months, 6 months, 3 months?
Mhm.
Because also those that award of damages, when parties go to the Court of Appeal, they've been overturned on the basis that sometimes when the court was giving you that 12 months or 8 months, they didn't tell us why they were giving. So
something so high.
Something so high. So
Mhm.
the court has room to play
Okay.
around with that.
So basically, here in the middle, this is the right way
Yes.
of terminating a person.
Mhm.
So the more you move towards the doing them wrong as an employer, the higher
Yes.
the amount of damages they get.
Yes.
Okay.
And also as an employee,
Mhm.
if your conduct contributed, because sometimes you have cases where
Mhm.
the employer maybe took through an unfair process,
Mhm.
but when the court looks at the reason, it was a good reason, maybe they just didn't give you the process. Those are the balances they use to weigh
Okay.
what kind of compensation you get.
All right.
Yeah,
So
it
they
could
look
move
at the
this way.
reason
Yes,
and the process.
and the process.
If at least one was a tick,
Yeah.
then you get less damages.
Ordinarily,
Yeah.
but
Yeah.
there's no hard and fast rule.
Okay.
Yes.
So let's look at reinstatement,
Mhm.
because I think it's also pretty controversial in the
Yes.
courts,
Yes.
because basically it's saying that you and your employer have broken up, and then I am, me as a court, I am basically telling forcing the employer to take back a person that they have already let go of. What is the attitude of the courts towards giving this order?
Okay, so for reinstatement, the first thing is it needs to be pleaded, and by pleaded means you have to have specifically asked for it in your suit for the court to even consider that as a remedy. And then secondly, the courts normally consider the practicability of that order of reinstatement, because you can find that you are being reinstated to a post that is realistically not there anymore.
Yeah.
Because we know our cases drag in the courts.
Yes.
If I was an accountant in Department A, by the time my court process is ending, Department A was shut down and maybe shipped to India. There's no other place for me to come to. So that practicability affects the ability of the court to order that
reinstate you.
Secondly, the reinstatement is limited to a period of 3 years between which the parties exited. So if I left employment, let's say in 2016, and now the court is ready to give its judgment in 2021, then the 3-year period lapsed.
It's already too late to take you back to your employer.
Yes.
And I think that's reasonable, because in that period of time, even the business could have changed, the policies, all the things you thought you knew, you no longer know them.
Yes.
Oh, okay. So now, what does the court consider in terms of the conduct of the employee and the employer towards agreeing to give those orders or not?
The court normally considers whether or not, of course, the employee wants, because it's, as you said, it's not supposed to be a situation where two parties are forced together. And also the law under Section 49 of the Employment Act obligates the court to consider the practicability of that. There's a common law principle that you cannot order specific performance of an employment contract or this kind of contract. So you
can't force you to employ this person.
Yes, and reinstatement is ordinarily a specific performance of that contract.
Yes.
So the courts have to be alive to that.
Okay. So you said towards the end of the broadcast, you'll tell us how the courts have...
Yes, not given compensation.
Yeah.
So we've seen cases coming up in court where the conduct of both parties was wanting. For example, I know of a case where an employee went to court claiming unfair termination, and the employer also brought up the aspect that this person, when they left employment, they left with a laptop belonging to the company, and it has sensitive company information. We've been asking this person to
bring it back, and
they have never. And the person also could not explain to the court why you didn't return that. So you see, in the whole scheme of things, your conduct also
determines whether you get damages or not.
Yes, so the court found that it would not really be fit to reward such conduct by giving you compensation. Yet you are here willfully saying you've withheld sensitive company information. So it's
actually good defense for the employers if they're able to show that this person truly was not their conduct was not good, or that they were not performing.
So I think the underlying message is that the court will look at the truth. The truth of the matter, basically.
Okay.
The court will look at it holistically. So if you're a claimant and you've gone to court and you also have, how can I say, skeletons in your closet and they come up, then definitely that will be considered. And for employers, the same, because the worse your conduct, the worse the compensation granted. So the court is actually, I would say, down to earth on that.
Okay. All right. So if you think you've been unfairly terminated and you're considering going to court, those are some of the things that you can ask for. You can ask for the time, the compensation within the notice period that you were not given. You can ask for damages up to 12 months. You can ask for reinstatement.
Yes.
And if you're an employer and now you find yourself in court, then the conduct of this employee will also determine how much damages you're told to pay. It's been a great broadcast. I've actually learned quite a lot just sitting here. Thank you so much for coming.
Thank you too.
If the viewers want to contact you, how can they reach you?
They can reach me through you.
Employed.
Yes. So any questions that you have, you can channel through Sian, and I'll be able to get back to you.
All right. So how to reach Sian? info@cyroglobal.com. That's info@cyroglobal.com. You can also write to us on our old Gmail address, that is cyrologlobal@gmail.com. We would like to say thank you to our videography crew, that's Moshiri Frames. Their address will be on the screen. And to J. Ojuma Advocates for facilitating the shooting of this series. Take care of your loved ones. Bye.